Pulling up Twitter for its continual non-compliance with Indian IT rules, the Delhi High Court has asked the social media giant to file a notarized and scanned affidavit within 2 weeks, questioning the use of the prefix interim in appointment of the resident grievance officer, chief compliance officer and nodal officer. As per law, the court has asked for a written undertaking from the Indian resident interim officers that they will bear full responsibility for the company's compliance with Indian law. Noting that the American social media giant was already in violation of the May deadline to comply with Indian IT rules, the single-judge bench of Justice Rekha Palli observed that Twitter had committed contempt of court by not filing a final affidavit despite having resolved to do so on the previous date of hearing. The court deferred the hearing for 28 July and refused to give a time of 8 weeks sought by Twitter for compliance with IT rules. However, Centre objected to no action taken by court against Twitter, claiming that no American court would have ever granted such a leeway to a pharma or an IT company. Questioning Twitter engaging services for an interim officer through a third-party contractor, Centre pitched for accountability of certitude and full compliance with Indian law while criticizing portions of Twitter's latest affidavit. Twitter had sought a time of 8 weeks to hire compliance, nodal and grievance officers to comply with Indian IT rules. In an affidavit filed before the Delhi High Court, the social media giant has maintained that though it is striving to comply with the Indian law, it has a right to challenge the legality of the IT rules. Twitter had indicated that it will present its first compliance report with IT rules to the Centre by 11th July and informed the court that it had appointed an Indian resident as interim chief compliance officer on the 6th of July, whose services, though, have been engaged via a third-party contractor. Explaining the use of the word interim in its affidavit, Twitter's counsel argued that Twitter Incorporated does not have a liaison office in India and is in a process of taking permissions. It's operating from a third party's office in India. Since a physical office in India is needed for significant social media intermediaries as per IT rules, Twitter claimed it has made interim appointments as it does not have a permanent office in India. Appearing for Twitter, senior lawyer Sajan Puvaya submitted that opening of a permanent office in India will lead to tax issues and therefore the company is using a physical contact address in Bengaluru for now. Though Twitter assured the court that its legal obligations under IT rules will be fulfilled by its interim officers, Centre termed the company's following statement in the affidavit as diplomatic and unclear, which read that endeavour in good faith will be made to make an offer of employment to qualified candidates in 8 weeks. It remains to be seen what further course of action will be taken by the union government, since Twitter does not have any immunity from law in India anymore.